Imagine waking up tomorrow to find your green card application denied, not because you did something wrong, but because of a single missing document you didn't even know you needed. For thousands of immigrants across America right now, this nightmare is becoming reality. The USCIS has just rolled out controversial new denial rules that are sending shockwaves through immigrant communities. And if you or someone you love is in the immigration process, what I'm about to tell you could change everything. Welcome back to the channel. Today we're diving deep into something that's affecting hundreds of thousands of people right now. The USCIS's aggressive new denial policy that's putting green cards and visas at serious risk. This isn't fear-mongering. This is what's actually happening in immigration offices across the country. And by the end of this video, you'll understand exactly what these changes mean, who's being affected, and most importantly, what you need to do to protect yourself. So hit that subscribe button because this information could literally save your American dream. And let's get into it. The United States Citizenship and Immigration Services has fundamentally changed how they handle applications, and the numbers tell a disturbing story. What used to be a process where immigration officers would work with applicants to correct mistakes and gather missing information has transformed into something much harsher. Under the new guidelines, USCIS officers now have unprecedented authority to deny applications outright without giving applicants a chance to fix problems. This represents a complete departure from decades of immigration policy, and it's catching people completely off guard. Let me break down what's actually changed. Previously, if your application was missing evidence or had errors, USCIS would typically send you a request for evidence, known as an RFE or a Notice of Intent to Deny, called ANOID. These documents gave you a chance to respond, submit additional materials, and correct any problems before a final decision was made. It was like getting a warning before failing a test, giving you time to study and improve. But now, immigration officers can skip these steps entirely and move straight to denial. They have what's being called discretionary authority, which is a polite way of saying they can make judgment calls that can end your immigration journey without warning. This policy shift affects virtually every type of immigration application you can think of. Green card applications through family sponsorship, employment-based green cards, visa extensions, adjustment of status applications, work permits, and even citizenship applications are all now subject to these stricter standards. Nobody is immune, and the impact is being felt across every immigrant community in America. The statistics are alarming. Since these policies began rolling out, denial rates have spiked dramatically. Applications that previously had a 70 to 80% approval rate are now seeing rejection rates climb to 40 or 50% in some categories. We're talking about tens of thousands of additional denials compared to just a few years ago. Real people with real lives are being caught in this bureaucratic tightening, and the consequences are devastating. Consider what happens when a green card application gets denied. Years of waiting, thousands of dollars in fees and legal costs, all potentially wasted. Families get separated. People lose their legal status and face deportation. Businesses lose valuable employees they've invested in training. Students see their dreams of building a life in America crumble. And here's the kicker. Once you're denied, reapplying becomes exponentially harder because now you have a denial on your record that you have to explain and overcome. So why is this happening? The official explanation from USCIS is that these measures are designed to improve efficiency and reduce fraud. They argue that by giving officers more discretion, they can process cases faster and weed out weak applications more effectively. The agency claims this protects the integrity of the immigration system and ensures that only qualified applicants receive approval. On paper, that might sound reasonable, but the reality on the ground tells a different story. Critics, including immigration attorneys, advocacy groups, and even some former USCIS officials, argue that these policies are less about efficiency and more about restriction. They point out that the policy gives individual officers enormous power with very little oversight. One officer might approve an application that another officer would deny, creating a lottery system where your fate depends on who happens to review your file. This introduces subjectivity and potential bias into a process that should be objective and fair. The burden of proof has also shifted dramatically. Immigration law has always required applicants to prove their eligibility, but now that burden has become much heavier. Previously, if something in your application was unclear, you'd get a chance to clarify. Now, if an officer finds your evidence insufficient or unclear, they can deny you immediately. You're expected to submit a perfect, comprehensive application the first time, with no room for human error or miscommunication. Let me give you some real-world examples of how this plays out. A software engineer applying for an employment-based green card submits his application with all the required documents: his labor certification, his employer's financial statements, his educational credentials, everything. But the USCIS officer reviewing his case decides that the job description doesn't quite match his actual duties based on their interpretation. Instead of asking for clarification or additional evidence, the officer denies the entire application. Years of work gone. Now the engineer has to start over, reapply, pay all the fees again, and hope the next officer sees things differently. Or consider a woman who's been married to a U.S. citizen for 3 years, living together, filing joint tax returns, the whole 9 yards. She applies to adjust her status to permanent resident. But there's a small inconsistency in the dates on 2 of her documents. Maybe her lease shows she moved into their apartment in June, but another document suggests July. Instead of asking her to explain this minor discrepancy, the officer suspects fraud and denies her application. Now, she's not only denied, but potentially facing removal proceedings because of what amounts to a paperwork error. These aren't hypothetical scenarios. Immigration lawyers across the country are reporting dozens of cases just like these. Applications that would have sailed through just a few years ago are now being rejected for reasons that seem arbitrary or overly technical. The appeals process exists, but it's time-consuming, expensive, and has no guaranteed outcome. Many people simply can't afford to fight a denial and end up giving up on their immigration dreams entirely. The impact extends beyond individual applicants. Businesses that sponsor foreign workers are finding it much harder to bring in talent. This affects innovation, competitiveness, and economic growth. Universities are struggling to retain international students who want to transition to work visas after graduation. Healthcare facilities in underserved areas depend on foreign-trained doctors and nurses, and these new policies are making it harder to fill critical positions. The ripple effects touch every sector of the American economy. So what can you do to protect yourself? First and foremost, perfection is now the standard. Your application needs to be absolutely bulletproof. Every form must be filled out completely and accurately. Every question must be answered clearly and consistently. Every piece of supporting evidence must be included, properly organized, and clearly labeled. This is not the time to cut corners or assume anything is obvious. If there's any way an officer could misunderstand or question something, you need to address it proactively. Documentation is everything. Whatever you're claiming, you need solid evidence to back it up. If you're applying based on marriage, don't just submit the minimum required documents. Include photographs spanning your entire relationship. Get affidavits from friends and family. Show joint financial accounts, insurance policies, property ownership. Create a comprehensive picture that leaves no room for doubt. If you're applying for an employment-based visa, make sure your employer provides detailed letters explaining your job duties, why you're qualified, and why they need you specifically. Get everything notarized and certified when possible. Consistency is critical. Everything in your application needs to tell the same story. The dates on your forms need to match the dates on your supporting documents. Your explanations need to align across different parts of the application. If there are any inconsistencies, address them directly with explanatory statements rather than hoping the officer won't notice. Remember, they're now trained to look for reasons to deny, not reasons to approve. Honestly, at this point, trying to navigate this process without professional help is like performing surgery on yourself. Immigration law is complex under the best circumstances, and these new policies have made it exponentially more complicated. A good immigration attorney knows what officers are looking for, understands the current interpretation of regulations, and can identify potential problems before you submit. Yes, it costs money, but it's far less expensive than having your application denied and starting over, not to mention the emotional cost and potential legal complications. If you're already in the middle of an application process, stay vigilant. Respond to any communications from USCIS immediately and completely. If you do receive an RFE or NOID, treat it as the serious matter it is. Don't miss deadlines. Don't submit incomplete responses. This might be your only chance to save your application. Check your case status regularly online and make sure USCIS has your current address so you don't miss important notices. For those watching who aren't currently in the immigration process but might be in the future, start preparing now. Gather your documents. Make sure everything is organized and accessible. If you're married to a U.S. citizen or permanent resident, start building your evidence of a bona fide relationship now, not when you're ready to apply. Take photos together. Get on joint accounts. Create a paper trail that demonstrates your life together. If you're hoping for an employment-based visa, work with your employer to document everything about your role and qualifications. The immigration landscape in America is shifting, and these new denial policies represent a significant hardening of attitudes toward immigration at the administrative level. While Congress debates comprehensive immigration reform that never seems to materialize, agencies like USCIS are implementing changes that have immediate, dramatic effects on real people's lives. Whether you view this as necessary enforcement of existing laws or as an unfair restriction on legal immigration, probably depends on your broader views on immigration policy. What's undeniable is that the system has become more adversarial. Immigration officers are no longer partners helping you navigate the process, but gatekeepers looking for reasons to say no. This creates a climate of fear and uncertainty that affects not just applicants but entire communities. The stress of facing potential denial, separation from family, or deportation takes a real psychological toll. And the financial burden of preparing applications, hiring attorneys, and potentially reapplying is crushing for many families. There are also broader questions about fairness and equity. Those with resources can afford experienced attorneys and comprehensive documentation. They can take time off work for interviews and appointments. They have the literacy and language skills to understand complex requirements. But what about everyone else? These policies disproportionately impact vulnerable populations who may not have access to legal help or who struggle with the bureaucratic complexity of the system. Is that the kind of immigration system we want? One where your success depends as much on your resources as your actual eligibility? So there you have it, everything you need to know about USCIS's new denial rules and how they're putting green cards and visas at serious risk. This is the reality of immigration in America right now. Stricter standards, less forgiveness for errors, and higher stakes than ever before. If this video helped you understand what's happening and how to protect yourself, please hit that like button and share it with anyone you know who's going through the immigration process. This information could literally change someone's life. Subscribe to the channel because we'll continue covering immigration policy changes as they happen, and you need to stay informed to stay ahead. Drop a comment below and let me know your thoughts or if you've been affected by these policies. I read every comment and your stories matter. Remember, knowledge is power, especially when it comes to protecting your future in America. Stay informed, stay prepared, and don't let these new rules catch you off guard. Until next time, take care and good luck with your immigration journey.